accessible as possible. Um, and we are going to do kind of a deeper dive into some substantive issues. Generally, when we're doing these presentations, we gloss over things, but in the last few months, it has, you know, come to my attention, or questions and conversations and things have led me to believe that a deeper dive is warranted. And the other, I will say a couple more things. Eric Spencer is a lovely staff attorney. He's also the coordinator of our outreach efforts and programs. So if you are interested in other presentations, maybe for community partners, or participants at community organizations, anything. If there is a need, we want to meet it. And as we are entering our priority setting season, we are doing our best to rethink the way we have our tax priorities written. So right now they just read like like case selection criteria, and that's one issue. But the other issue is it is really difficult to insert race equity work into tax by design. When a system seems banal, it is ripe for abuse, right? And so the way that we are choosing to approach this moving forward is to reflect on the priorities that the other practice areas set and incorporate those priorities into ours. So we have our list of the types of cases that we do, but why we're doing it, we haven't spent enough time developing and fleshing out, and we've been doing a lot of time, or we've spent a lot of time doing just that. So it's a work in progress, but we're hoping with our updated priorities that the values of our clinic and the values of the other practice areas across Oregon Law Center and LASO are reflected in those clinics, because we want to amplify the work that is being done in our organization, where we for so long were siloed, and now we're really just trying to embed ourselves in everything that people do. And one more plug for Eric is he's a former law clerk. So clerking at LASO gets you hired. Yay. So I will get started. And Eric is going to help me moderate the chat and the questions. So if you have a question and you feel comfortable using your voice, right, use the raise hand function, and Eric will call on you. Introverts have feelings too. And so if you don't want to raise your hand and say something, putting questions in the chat or comments in the chat are also very valid ways of participating. And if you're like me and you have ADHD and you make a point, and then more conversation happens and you develop a more nuanced point and you don't want to keep barging in and talking, chat is also a really good tool for that. So we will be looking at that, and feel free to raise questions, comments, concerns at any time. We want this to be a useful presentation, and so interruptions are par for the course, because we want to make sure that we are really interrogating the things that people have confusion or curiosity about. So without further ado, I will share my screen and we can get this show on the road. Does anybody have any questions or anything before I start? Okay, well, all right. So, here are some things that we're going to cover today, just to give you an idea. We're going to dig into the Form 1040, so people know exactly what this tax document does and why the things that we talk about matter, and hopefully help like people orient their brains around where the things we're talking about live in the 1040 form, because I feel like the 1040 form is something we all interface with and we have no idea what it does in many cases. I didn't know what it did, and sometimes I still forget. So we're also going to talk about tax benefits for households with children, child custody agreements and the things that can be included and the things that cannot be included, And then we're going to talk about common issues for divorced and separated parents and how to get assistance from our program. So to start it, we have this beautiful form and it has a lot of information in it. So the outline might be easier to digest on a daily basis, but to just give you an idea of what this form is doing. So the first section is income. It is adding up all of your income from everywhere you might receive it. So lines 1 through 9, it is all about determining what your total income is. And this is the number that tax advocates highly suggest be used in support agreements and determining support. Because the adjustments to income, which is the next thing, and the Form 1040, what we use to determine your adjusted gross income, those can be misused and inflated to bring down somebody's adjusted gross income just for the purpose of making it look like they make less when having support determined. So I don't think you can say it has to be the total income, but it is highly suggested. And some people might know more about this than I do because I don't negotiate support agreements, but adjustments to income can be things such as educator expenses and other things. And so those bring down your total income, and that's what's encompassed in the adjusted gross income. And all of this is coming up to what the IRS views as your taxable income. And then the IRS has tax tables, and depending on the politics and what's going on in Congress, the tax tables will either be very simple or very complicated. And that is an ever-moving target. But there are tax tables available for anybody who wants to see them. And that's how it is determined how much tax somebody might owe. And then we start to get in above the line and below the line issues. So when we talk about above the line issues, we're talking about all the things that might whittle away the tax that you owe that will not result in a refund. So those are your non-refundable credits and things like that. And then when we get below the line, we get to refundable credits, we get to tax payments and all of those things that will further whittle away the tax if it hasn't been whittled down to zero with the non-refundable things, and it can come to the other side and result in a refund. So when people are preparing their taxes, and if you go to tax planning seminars that are by wealthy people for wealthy people, they're trying to figure out what is, your income. They're trying to make the adjustments to that income as much as possible, so that when they get to the deductions, there's less to deal with. Then they're really going to want to look at whether you are using a standard deduction or an itemized deduction. For itemized deductions, they're going to want it to be as high as possible, all with the effect of making that taxable income number as small as possible. And then that makes the tax owed as small as possible. And then any credits that might be available to folks, you want to really find all of them so that you can get what you have to pay at the end of the year down to zero, or you can even get a refund. Obviously, we want this done ethically, and we want people to pay what they owe and be paid what they are owed. But this kind of sets out, when we're talking about certain things, where they're going to show up on the tax return and why it matters. Does anybody have any questions about this form and the blabbering I just did before I move on? Okay, so there are a handful of benefits for households with children. There's head of household filing status if you're not married but have children. There's the dependent exemption, the child tax credit, the tax credit for dependent care, exclusions from income for dependent care, and the earned income tax credit. We are going to focus on head of household status, child tax credit, and earned income tax credit, but the outline is going to have explanations of all of those things. So filing status is important because you get a different deduction amount. depending on your filing status. If you're single, it's one amount. If you're married filing separately, it's the same amount. If you're married, it's more. And if you're a head of household, it is more. So this reduces how much your taxable income is going to be. It's the line just below adjusted gross income. So you are considered single if you are unmarried, divorced, or legally separated on the last day of the year. So if I am married and have a divorce finalized on December 31st, 2024, I'm single that year, even though I was married the whole year. And the same thing is true for head of household. And the addition is that you have provided more than half of the support for your home, and your spouse didn't live with you for the last 6 months. So it's a little bit of an adjustment to the single. You have to be separated for the last 6 months of the year. And you need to have a child or qualifying relative in your home. And the dependent exemption we're going to talk about briefly because it doesn't matter right now, but it is one of the benefits that are negotiated in custody agreements. The dependent exemption prior to the Tax Cuts and Jobs Act, prior to the Trump era tax bill, used to provide an exemption of income in the amount of $4,050 for each taxpayer and their dependents. So this whittled down what was even countable as income. And that went away with the Tax Cuts and Jobs Act, but that provision sunsets in 2026, and Congress being what it is, unless they extend it or amend it, it's gonna come back to the way it was before 2017. So who knows, but this might matter in the future, which is why I thought important to mention. So tax credits, these are the things that pop up on the second page of your tax return. They're either going to bring the tax you owe down to zero, or they're going to give you a refund on the other side of zero. So there's the child tax credit, and this is a little bit confusing because we called the child tax credit and the additional child tax credit all the child tax credit, but they're really two different credits. The child tax credit is the non-refundable portion, and the additional child tax credit is the refundable portion. I think people, when they hear those two things, think, I have 2 children, so I've claimed the child tax credit for one and the additional child tax credit for the other, and that is not it. You claim both for each child. And so they enhance the economic security of families, particularly our clients. The amount of credits is determined by income. It is a regressive tax credit. So the more income you earn, the bigger the credit. The less income you earn, the lower the credit. That's a problem, but it is what it is. So the non-refundable part of the child tax credit is $2,000. It's up to $2,000 per child. And so low-income taxpayers are going to get a smaller credit. And this one I'm not as concerned about because this can only bring your tax down to zero. So they're going to owe less tax as well. So even if we change the system to everybody gets $2,000 no matter what, or some other version, if somebody only owes $700 in taxes, that's really the only benefit they need. Now, the additional child tax credit is refundable up to $1,600 per child. And that's where the income really matters, because the more income you earn, the more likely you are to get a refund, and the higher that refund will be. The less income you earn, you might not be eligible for a refund at all. So that's what makes it regressive. Then we have the earned income tax credit. The earned income tax credit is a federal tax credit for working people with low to moderate incomes, and it's based on how much you earn and how many children you have. The table below is the current table for the 2024 tax year. So families with 3 or more children could get up to $7,830 in tax credit, and that is refundable. So if If the low-income family has whittled their tax debt down to zero and they have the earned income tax credit, they could receive that full amount in the form of a refund. It is a very effective refund tool. And so those are kind of the nuts and bolts. And why do they matter? So we talk about the tax credits, we talk about claiming children on taxes for the purposes of custody agreements, and why does it matter? Why do we need to care about these things? Why are they not just another line item in an agreement? So the majority of our country's social safety net is embedded in the tax code. The earned income tax credit and the child tax credit are the largest federal cash benefits that families can receive. They don't count as income for other needs-based support, and they're not taxable. So it's cash that families can get to pay bills, to support themselves, to buy food, to pay for rent, any number of things. So in the effect that these credits have, and this isn't hyperbole, they break the cycle of poverty in families. So children who are in households who receive the EITC and the child tax credit have high rates of being lifted out of poverty. So I believe in 2018, 10.6 million people were lifted above the supplemental poverty line. And poverty was made less severe for 17.5 million others. That's a lot of people. What studies show time and time again is that for every $1,000 increase in annual income for families over the course of 2 to 5 years, children's school performance improves, their test scores improve, their health outcomes improve, and the instance of instance of poverty-related child health conditions goes down. So these credits, they help people do better in school, so they're more likely to graduate. If they graduate, they're more likely to attend a college. If they attend a college, they're more likely to finish. If they finish, they're more likely to get a better job. Families who receive tax credits don't have to move around as much. So they're more likely to stay in the same school district, more likely to stay at the same schools. So these are all the reasons that education outcomes are impacted. Families receiving tax credits can usually remain in neighborhoods longer. That creates economic diversity in neighborhoods. So it's not poor families getting pushed further and further as the poverty line of our county shifts, but it's families who might be low income, receiving tax benefits, living in school districts with people of higher means and higher income. So they're going to be at better schools in general, better facilities, all of those things. So yeah, this is why tax credits matter, and this is why they matter to family law attorneys. They're very important and they're very vital to low income and working families. Before I move on, I want to make sure there aren't any questions. Okay. So as we continue, this is where we bring the family law into the braiding of things. So when we think about custody, family lawyers tend to have a pretty good idea of what custody means for courts. But I don't think family law attorneys always have a good understanding of what custody means to the IRS. They're not the same. So legal custody, a decision about who can make decisions, sole custody, joint custody, all of those things. Parenting time, the amount of time that child spends with parent. The IRS, in their definition of custody, attempts to take both of those concepts and put them together. So for the IRS, regardless of what a court says, the person with custody is the parent with whom the child has lived for the greater number of nights during the year. So parenting time and custody agreements is very important because you can be granted sole custody, but if you have fewer nights, you are not the custodial parent. And then qualifying child. to claim a child on your tax return, they need to be called a qualifying child. And there are 4 general tests. They need to be related to you by blood or by law. They need to live with you for a certain number, for 6 or more months in the year, I think is the definition. They need to be a certain age. For most credits, it's 19 or 24, depending on schooling, but the child tax credit has its own age. And support for most of the tax benefits that we talk about, the child can't provide more than half of their own support. I think people get confused and think that a parent needs to provide more than half of the support. But for the qualifying child test, it's just that the child isn't providing more than half of their own support. Head of household is like a little different. That status requires that one parent is providing more than half support, but there are lots of treatises on what counts as a parent providing support, tax benefit or public assistance benefits and things like that. When is it considered the parent providing support and when is it not? And we won't get into any of that today. If people want to wax poetic about that with me, I'm happy to do that offline, but there are a lot of materials. And I do see that Nellie has a hand raised.
Yeah, thank you. I just wanted to kind of like clarify for the relationship part, you mentioned that should be related by law. Does that include a step parent?
Mhm.
Um, because there's a lot of those for our
Yes.
clients who remarry.
Yes, yes.
Okay.
If you, it's by blood or by law. So if you are partnered with somebody and not married, but you are able to adopt their children, good. If you marry somebody with children, you're good. If you bring in your siblings' children, you're good. You just need that relationship.
But no need to have like guardianship or an actual like adoption situation.
No, not if you're married. If you're unmarried cohabitants and there's children, then there are requirements to have more legal process to validate your relationship, I guess. Codify. Deborah?
The part about the parent with who is the custodial parent for the purposes of IRS if the child lives with one parent more. And then if it's 50-50, I see your extra bullet that says if it's the parent with the higher gross monthly income. If we have 2 parents who are imputed minimum wage and have said they're going to do 50-50 parenting time, will the IRS go with the statement in the general judgment that says mom shall claim the children? So what do they do if they both are imputed minimum wage and it's 182.5, whatever the half is?
Yeah. Yeah. So um I'm going to put a pin in part of that because we're going to get to some of that in a little bit. But whatever the order says is the IRS is not concerned with it. The reality, so if we say we're going to do 50-50, what's actually happening? So we need to tell our clients, you need to keep very detailed calendars. You need to keep track of how often. Because if you want to claim your child in a particular tax year, you need one more day. Even if it's 50-50, you need one more overnight. And the only way to do that is through self-advocacy, because we know that abusers and people who manipulate power systems are going to be pretty clever. And financial abuse is so insidious, and this is ripe for abuse. Especially because the IRS isn't looking at the divorce or dissolution or custody agreements. They're just looking at the reality. And the reality is people with more power are going to exercise more power. So being very clear with our clients when we are advising them about what they need to keep track of and how they need to advocate, and if things are getting off the rails, when to jump back into court. Because if it's like, if the other parent is able to abuse this agreement, they're going to lose those benefits. Yeah. So moving on. So it gets a little squirrely with qualifying children and custody agreements. And this is a table that is a little chaotic looking because it is a little bit chaotic looking. So for the tax benefits that we are focusing on, the requirements are like there needs to be a social security number or ITIN only like for head of household and dependents. You can have an ITIN and that's fine. You don't need a social security number. But if you are a married couple or head of household and you want the earned income tax credit, you have to have a social security number. And if you're married, both parents have to have a social security number. And you cannot pretend you're not married and do head of household and single so that you can get the earned income tax credit. Both parents need to have a social security number. For the child tax credit and the additional child tax credit, children are required to have a social security number. You know, it's our nationalistic, xenophobic, the way things get codified into the law. And so we talked about relationship, we talked about age a little bit, and the residency, you have to have lived with a parent for more than half the year. And there are some special rules, and these special rules apply to only 2 areas. And this is where I think we've gone astray from tax law in the recent, I guess, recent present, I don't know, recent times, but the only 2 things that a parent can claim by agreement, if the child has not lived with them for more than half the year, is that dependent exemption that we don't get anymore, but might get if the Tax Cuts and Jobs Act sunset, and child tax credit. That's it. That's it. Because there's a special rule for those 2 things. There isn't a special rule that exempts the residency requirements for head of household or the earned income tax credit. And then EITC is the only one that doesn't require a showing of support for the child, but the other ones, the child must not have provided more than half of their own support. So,
Shannon,
yes.
before we move on, quick question in the chat. That chart that you provided on the last slide, that's going to be in the materials that we send out, right?
Yes.
Okay, great.
Yeah, and if you really like, I'm always looking these things up. Even though this is my practice area, I know that these things change based on political whim. And so if I'm looking at a particular thing, I will often Google IRS EITC qualifying child, IRS CTC qualifying child, because there are breakdowns of who a qualifying child is for each benefit. And I can provide links to those for people as well in the materials that I send out. But just in the, in the interim, Google Tax Lawyer is a very useful aggregator of resources. So to get to Deborah's point in her question. Oh, is there anything else in the chat before I move on? No, okay. So qualifying child can only be used by 1 taxpayer, not by 2. There are times when somebody is a qualifying child of 2 parents. So if we think about parents who live together for most of the year and then separated and were divorced, and that child lived with both parents for more than half of the year because maybe they separated in August. So child lived with both parents through July, 7 months together. And then for the remaining months, they did 50-50. Well, that child has been with both parents the same amount of time. That's when the IRS gets into its tie-breaking rules, and that's when the AGI will prevail. So if you know that your client makes less money and is going to be a qualifying child of both parents, you're going to want to put something in your equalizing judgment to make up for the fact that even if your client isn't going to have custody, they will next year. And so how do you make that come out? How do you make the equities come out in the wash on the first year when that child might actually, for tax reasons, be the qualifying child of the other spouse? Okay. So we talked about the special rule This is the verbatim language of the IRS. So we're not going to get too much into it. We're just going to know that that's going to be in the materials, and we've talked about the useful portion of this, but I wanted you to have it. Okay, so let's think about this in real time, right? Okay, so thinking about custody and custodial parenting in the eyes of the IRS. Let's say that we have a custody agreement between parent A and parent B, and parent A is given sole custody. For the IRS, who's the custodial parent? I'm going to call on Eric.
Whoever has the child for 6 months and a day.
Yeah, so based on
Throughout
this,
the
we
year.
don't know. We don't have enough information. It's a trick question.
Mm.
We don't know. We don't have enough information. Okay, so let's take this scenario. Child, parent A is given sole custody. Child lives primarily with parent B. Deborah, who is the custodial parent?
Parent B.
Yes, that is correct. Okay, so now let's expand. Child, parent A has sole custody. Child lives with parent A during the school year and parent B during the summer. That's probably going to mean parent A is the custodial parent. And so then if parent A agrees to alternate the child on, alternating tax years for the years that parent B gets to claim the child, what does parent B get to claim? I'm going to call on Rachel Federico because I know she's in here.
Hello.
Hi.
Let me start my video. Sorry, I was stuffing food in my face. Okay. So you're wanting me to answer one?
Yeah, like if parent A has sole custody and they're letting parent B claim child in alternating years, what benefits do they get to claim? Do they get to claim head of household?
So you had said that it depends on the amount of time that the child is actually residing rather than what the judgment itself says. So
Yeah.
I think in this situation, I would need to go and figure out how many days in the year, and specifically you had said 6 months, right, at least. And I would need to like physically mark off probably on a calendar and make sure that the number of overnights was consistent regardless of the text of the judgment.
Yeah. Yeah. So the reason that I'm belaboring this is because I feel like I've seen a shift in custody agreements to include provisions that are not enforceable under the law. And it's one of these things where I've had meetings with IRS counsel and we both rip our hair out for the same reasons. And when your adversary is agreeing with you that there's a problem, it's a big problem because they see more of these than I do. But so I don't want to harp on people because it's not anybody's fault. I would actually say shame on the judges for allowing things into custody agreements that are not lawful. That is a plain error, So I don't know, open up some of those agreements. If
You're
you're
speaking my plain error of Hellet language, Shannon. I love you.
Yeah. So if there are really terrible custody agreements that you haven't figured out how to challenge, you might have some appeal rights. But that's Rachel's territory, though. I'm not going to step where I don't belong. And yeah, so the same thing goes for joint custody. It really, the legal custody doesn't matter. The benefit is conveyed to the person who has the child most. And if we think about the reason for that, the IRS is trying to benefit the parent who's more likely to be making school lunches, is more likely to be making dinner, buying clothes. Is it always true that the place where the child spends most overnights is the parent who spends more money? No, but the IRS has to draw the line somewhere, and the goal is to benefit the child. So, so if that's the spirit, then that's why the rule is what it is. And I see a hand by Charlie Allen.
Yeah, I just wanted to make sure that I understood the point that you're trying to drive home, which is that even if we come to an agreement with an opposing party about some of these credits and who they might be available to, at the end of the day, it's going to be the IRS code that's going to trump that. So we can put whatever we want in our judgment, but at the end of the day, the IRS is going to go, I don't care what you put in your judgment. That's not what is playing out under the IRS tax code. And so go pound sand. Is that right? I want to make sure I'm understanding that right.
You are exactly right. Yes.
Okay.
Yeah. The only two things that you can negotiate around with are the dependent exemption, which kind of doesn't matter much right now, could matter again in the future, and the child tax credit. That's it. Ya estuvo. So now we could get like 300 level analysis here, like, but what about when grandparents are involved? Uh-oh. Or other family members where the child might be overnighting. It's just like, if there are more than two people where the child is overnighting, you're going to have to pay closer attention. And then there's these oh my gosh, there's these really squirrely agreements where there's so much contention that they're literally looking like they're going to transfer the child on that one extra day at midnight. So nobody has more overnights. Don't do that. If people are fighting that much about parenting time, I don't know what to do. But like you can get so granular and so strange in ways with this like 50-50 time that you might inadvertently be making it so no one is the custodial parent. And we don't want that. So we won't belabor it too much now, but if you have questions and you want to talk through things, that is a really good time to maybe do like the 200 level presentation, or just like contact us and we will talk through things. But yeah, it gets really complicated with other family members spending time with children. And then if there's a lot of conflict around how many hours of the year the child is going to spend and how many, those things can get as you know, can get heated. But again, if you're keeping score at home and you're making sure that you have more overnights and you have at least 6 months of overnights, then you are the custodial parent for the IRS. I see Patrick Cheney's hand.
Hi. I don't do this stuff as much. And I'm thinking maybe as much as I should, which is what I frequently think when I hear a good presentation. So say that, like, I hear that these facts probably exist, just like in the course of landlord-tenant representation. What should we be doing if we hear that, potential client's abusive ex who isn't involved in this matter is claiming head of household independence and probably shouldn't be? But we don't have the bandwidth to do full rep. Is that something we refer? Is there some place that they can complain to? What do we do with that?
Yeah, you refer those folks to me.
Okay.
And we will take care of them. Yeah. We want to help.
And then Shannon, we've got a question in the chat too.
Yes.
What would the language say that would allow the parent B to take the EITC while parent A is the custodial parent per the IRS?
You would, if you want a true alternating year agreement, you would need the years, even years, odd years, I think is the way it gets kind of split up. And if you want a parent to be able to claim in the odd years, then you have to have in the agreement that parent is going to have more overnights. And you have to do it. So the agreement can say whatever it wants, but you have to do it as well. So if you're contemplating a true 50-50 or a true alternating year agreement, then parent A needs 6 months plus 1 day on the even years, and then parent B needs 6 months and 1 day on the odd years. And then that's how you can do the alternating agreement. But you can't just say, we're going to alternate. You need to put some math in there, and you need to have a plan that's followed. I hope that helps. Okay. So this is just a recap, and we've kind of gone through this, but the custodial parent can claim the qualifying child for tax benefits like the filing status, dependent exemption child tax credit, earned income tax credit, and the others. The custodial parent can allow non-custodial parent to claim for the dependent exemption and child tax credit. And if you want that alternating agreement, then you have to do alternating time. And then tiebreaker rules apply when somebody's the qualifying child of both parents. So then we're going to move on because audits are an extension of this. Because audits are looking at who's claiming credits and are they allowed to claim credits. And an audit is the IRS's way of verifying accuracy. And the IRS uses a variety of methods to select people. None of them involve a human person. And so I hear a lot like the IRS is picking on me. The IRS doesn't like me. The IRS doesn't know you. There's no human person involved with selecting audits. Well, in circumstances that don't pertain typically to our clients, perhaps yes, a person is picking somebody out, but the audits our clients receive generally do not have a human associated with them. They have a computer scoring system that creates little flags and have numbers associated with those flags. And if you hit a certain number, then you're going to get flagged for audit. And so sometimes it's just the IRS and its algorithm. Now, there's some unfortunate things with the IRS algorithm. For example, one of the income criteria for their income tax credit is that you're low or moderate income. One of the things that'll flag you for audit when you're claiming children, that you're low or moderate income. So they may remove credits and flag you as suspicious because the thing that makes you eligible for the credit is also the thing that they think makes you ineligible for the credit. It's fun. It's a real fun ride and it's preposterous, but that's why we're here and that's why we want to help because it can be difficult for taxpayers to navigate this humanless system. And then another time that the IRS might audit someone is if more than one taxpayer claims a child. And, we have our really lovely custody agreements that we spend so much time negotiating and hammering out with opposing counsel or per se litigants. And then, pro se litigants are still going to be abusive sacks of turds. And so there is a common misconception that if I file the taxes first, I get the children. And that is not true. It is not true at all. So for our clients, if they think the other parent has claimed the children, and then they think they're not allowed to claim the children, that's not correct. So they might claim the child and the other parent might try to claim the child afterward. But if the other parent has already claimed the child on a tax return, and then our client tries to claim a child after that, they're going to be prevented from e-filing. It's going to be bounced out of the system. There's going to be an error. So then they'll know the other parent did claim the child. And so that's okay. Our client will just need to file a paper return, but they still get to file their taxes. And when that paper return is processed, both parents are going to receive a letter. It's called a CP-87. And essentially it says, hey, 2 people claim the same child. We're going to look into it. Just make sure that you put all the information in right. But if there's nothing to change, you don't have to do anything. And then the IRS is going to apply the tiebreaker rules. And so they're going to look to see first where the child lived. And if it's pretty clear, like child records are all in our client's address, then they're just going to resolve it for our client without doing anything else. If it's hard to determine where the child lived, then they're going to audit both parents. So most of the time when people get this letter, they don't have to do anything, but sometimes they'll then get an audit notice. And then we have to prove those tests that we talked about for the custody agreement. We'll have to prove them to the IRS. We'll have to prove the relationship, birth certificate, pretty easy. We'll have to prove the age, birth certificate, very easy. We'll have to prove where they lived. Depending on the age, it can be more difficult or more easy, but it's definitely doable. And then support. Did the child earn more than half of their own support? If the child's like 5, probably not. That's a non-issue. If the child's 16, then we might have to look at the child's income. But the most important thing is you don't have to do any of that. That's what we do, and we want to do it. I think audits are my favorite cases. They're frustrating because of the way the system works, but they're also very, like, I don't know. I just feel like I've put in a good day's work when I get an audit determination in our client's favor. I love audits, especially because they can take us to tax court, and oh, the IRS is full of ineptitude. But IRS counsel's office is very easy to work with. So any case that can convert to a tax court petition, I am so excited about, because IRS counsel's office is so easy to work with. Then we have math error notices. IRS was like, we made it really easy to audit people. We don't even have to have human beings doing it most of the time. But what would make it easier? If we could just take away people's rights to get an audit. So they've created these notices called math error notices. For the folks who are nerdy and pay attention to things, their IRS notice CP 11, 12, and 13. Those are the math error notices. And they basically say, we think you made a mistake on your return, so we fixed it. And let us know in 60 days if you disagree. Otherwise, we fixed it. And it takes away your right to go to tax court. So if you don't respond, you lose your right to go to tax court. It is a huge issue. It is a huge due process issue. If anybody comes to your office and has one of these notices, like, call me immediately, call me on my cell phone. I don't care what time it is. I want to open this case, because tax clinics across the country are mad about these notices. So there are times when it makes sense. Like, if you say that you didn't get your stimulus payments, but the IRS says you did, and you did, then they can fix it for you. That makes sense. It's a math error notice. Or if you put 2 + 2 is 5, and you compute everything based on that error, math notices are fine. But when we see math error notices saying, hey, we think you accidentally claimed children and you accidentally claimed head of household status, and we're removing those for you, that's where it gets problematic to us. So if you ever see these or a notice that smells like this, please let us know. We want to help. Then there are issues with, like, if you marry somebody that has outstanding debts, if you file a joint return with them and they have offsets through the Treasury offsets programs, or they have tax debt for prior years that you weren't in their life, your tax refund is going to get siphoned over to pay those debts. But if it's not your responsibility, you should get your portion of that refund. And so there's injured spouse relief for that. So if anybody says, hey, my tax refund got taken to pay my husband's child support arrears, let us know. We can help with this.
Hey, Shannon,
Yeah.
before we go too much further, I think Rachel might have had a question.
Oh, yeah.
Thanks, Richard. Okay, so this is going to be maybe a little bit of a troublemaking question. But this is like the overlay where the rubber meets the road, I think, in terms of practical assistance. So in family law land, say we have a prior judgment and it gives the right of one parent to file. And according to your wonderful presentation, let's say that the text of the judgment itself is in conflict, right? So tax rules are going to trump here, but we're not allowed to advise a client to violate a court order, right? So, like, if the judgment says parent A gets to claim, I don't think we're allowed to advise the client to go ahead and file in violation of that judgment, even if we understand that the judgment wouldn't be enforceable.
Mm-hmm.
And so, do I understand from your presentation that in that situation, the only thing that we can advise is we don't believe that this is enforceable, and you may want to have this modified because that could leave them vulnerable to losing a tax benefit they are in fact entitled to, but also we can't direct them to violate the judgment that's in place. Does that make sense?
Yeah. Yeah. And so I think, to the best of our ability, if we want this judgment to be enforced a certain way, we need to put, I would say, like thinking about the practical application, put in the language of like, this applies only when these conditions are met.
Right. So, I mean, let's say the client comes to you and there's already a pre-existing
Yeah.
judgment.
Then
Right.
you would tell them you want to consider modifying. I can't advise you to violate this order, but I can tell you what the tax benefits you're entitled to are. And then in the future, if you don't want to have this ethical quandary about whether I should file taxes this way or whether I shouldn't, then you might need to get a modification. And depending on what else is involved and included in that order, that may or may not be a good idea. So, right. And so that's one of those things that like then you'd have to I would advise against it based on X, Y, and Z, or I advise for it based on X, Y, and Z. And if the IRS were to audit this person, they're not going to get the benefits. So yeah, it's a little bit complicated with an order that's already signed because you don't want to open Pandora's box by modifying an order for one thing, right? So I would say if that situation comes up, that's a consultation that I'd be willing to do with someone to just kind of lay out like, here's the tax stuff and then the family law stuff, because I'm not going to know all the family law stuff. You're not going to know all the tax stuff. And this is why we have a wonderful partnership. Yeah, and it's literally our job. So the last thing I'm going to talk about, and I want to be aware of time because I know we've spilled out of 2 p.m. But there are also issues where there is tax debt that you don't know about until you have divorced your spouse. And there are 2 ways that these tax debts come up. Either a tax debt was owed during the marriage that was never paid. It's an underpayment. Or there's a tax debt that's owed as a result of an understatement. And this either comes from understating income or overstating deductions to income. So if you say that you can take more away than you can, and the IRS says, tisk, 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 you can't do that, they are going to take away that deduction, and then that's going to add to your taxable income, which is going to create an increase in the tax you owe, And so for folks who find themselves in this position because of next spouse, there is a form of relief called innocent spouse relief. This is your historical background. I think it's interesting because until 1921, married people weren't even allowed to file taxes together. And now the default in, 100 years later is that we often file taxes together, either jointly or separately, but most people file jointly. And when you file taxes jointly with a partner, you are also liable for all of their tax indiscretions that happen on that tax return. So there are reliefs for people. There is relief for people called innocent spouse. There's 3 types. We affectionately refer to them as B, C, and F relief because that's the provision where they're found in the statute. So type B relief and type C relief are only available for understatement cases. If you owe money and you know you owe money and you don't pay it, you can't get this relief. F relief is for both, and F relief is our equitable relief mechanism. So B relief is the hardest one to get. It's the least common, and it's the only one that will provide a refund for any payments improperly collected from the innocent spouse. everything else will just cut off the liability from that innocent spouse, even if they've been improperly collected against, it doesn't matter. And then they both have some sort of knowledge component. The innocent spouse should not have known of the error that caused the liability. For B relief, it's a higher burden, it's a higher standard, and that's what makes it harder and more rare. It's not just that you didn't have actual knowledge, you can't have constructive knowledge either. So if somebody in your position should have known, then you will not be eligible for this form of relief. And that is based on what's called the duty of inquiry. You can't just delegate taxes to one person and never look into it and not be expected to be held accountable. If you have done that, then you might be imputed to have constructive knowledge. So you might not have known, but maybe you should have known. And for our clients, the thing that is very important to know is that abuse interrupts this duty. Clients who don't feel like they can question things, even if they know about them, or clients who don't think they are allowed to know about them. They don't have access to bank accounts. They don't have access to income statements. They have no idea what their partner is doing with their day, whether the bills are getting paid or not. They haven't had the lights shut off, so they assume things are getting paid, but they just don't know anything, and they are not able to ask. Then those folks might still be eligible even when they know about the errors that caused the liability, because of how abuse impacts knowledge. And the IRS is usually pretty good at getting this right, for understanding when taxpayers did not know. They understand that objective piece. Where they get confused and they need our assistance to understand is that should have known, the constructive knowledge. They don't always understand how abuse impacts the constructive knowledge. So they're saying like, well, a person in your position, but they're not saying a person in your position who was abused this cruelly and treated this inhumanely. So they're missing that piece from their analysis. And sometimes we have to litigate that. I see a hand raised.
For the abuse piece, does there need to be a finding, like a restraining order, a police report, or can it just be a statement?
It can just be a statement. Usually a signed attestation is going to be enough. It's one of those things, though, that depending on the training and the cleverness of the IRS person, it's kind of not a question of if, it's when. So maybe the first person reviewing that petition or that request isn't going to understand that a signed attestation is good to go, but the next level probably will. And if not, then we get a ticket to tax court and IRS counsel's office. They will understand that that is sufficient. So the answer is yes, with the caveat of eventually. It's hard to know. It just depends on who's working on the case. But this is another case that we really want to take from folks. Lauren recently referred a case to us that we're working on. This to us is a really gratifying way, and I don't want to say simple, but I can't think of a better word. But it's just a nice way that we can amplify the work that you're doing for your clients if there is this outstanding debt. Because depending on how long client was married to their spouse, they might not have been married long enough to draw from their Social Security benefits. And part of this tax debt is going to go to that person's Social Security benefits. So that seems patently unfair to make somebody who's been subjected to extreme cruelty and abuse to have to pay somebody's retirement benefits, and they're not going to get any of them. It just adds insult to injury. It's a way, it's one of the ways that we can stand up to the abuser without making the survivor look like deal directly with the abuser, but we put the IRS in their place and we use the resources of the US government to stand up to that abuser. And it can be very validating for people. So I am compelled to take these cases. I think these are cases that we all generally feel very good about taking. And usually the family law advocate has a lot of the information and a lot of the documentation that we need, so we don't have to re-traumatize the client. We can just take the good work that you have done and use that to craft our requests for relief. So on that note, we want to represent your clients. Like I said, we want to amplify the priorities that each office is making for themselves through the surveys and all of that, time involved work that we take to set our priorities. So we want to amplify your work. And so if you are an internal referral, there's two ways that you can make, well, there's a few ways to make referrals, but if you are assisting somebody and it's very clear that there's an IRS issue, then you have our blanket. We are going to agree to full representation for all of your clients. It's not even going to be a question. We're just going to assign those cases to case handlers, and if it becomes overwhelming, we'll figure it out then, but that's a problem we want to solve for. So if you know that there's a tax issue, you have documentation, you can just open up a legal server case and assign it to Ruby, and just get us those tax documents and we'll figure out who will take it from there. If you work at the Oregon Law Center, you won't be able to do that, but you can send us an email that has like the case information of, the eligibility, all of the stuff that we would enter into legal server and any documents you have, and we will open that case for you. And if you are emailing those things to us, just make sure you put in brackets case referral, and then we'll know what that is, then we'll make sure to prioritize it in our email list. And so that's taxteam@lasoregon.org. And here's the good news. Lots of people think that LASO can't represent undocumented people. And that I don't like that characterization, because there's so many undocumented people we can help. And anybody that qualifies for family law services at Legal Aid or Oregon Law Center is very likely going to meet that exception. So don't worry about citizenship status or those sorts of eligibility criteria. We can figure that stuff out. And we do our best to take that line and go right up to it. No sunshine between us and the restriction, and everything that we really cannot take, we just work up very nicely and we give it to Catherine Williams at the Oregon Law Center with a big bow on top. And we just make it so easy for her to take the case. So if you send folks to us, we can figure out who's eligible for our services or not, and then we can make it a very smooth, warm handoff, so nobody's going to fall through the cracks. And if you don't know if there's a tax issue, but you have a client that's complaining about the IRS or complaining about taxes or what have you, you can use the link in this presentation, and they will be sent to a bookings page where they can sign up for an appointment with somebody in our office to talk through the things that they are concerned about, and we can advise them or investigate their tax issue and move that towards, if there is a tax issue and it's coming from Oregon Law Center or Legal Aid, we're going to move it to representation. So you don't have to do a lot of legwork. If you already have the stuff, we're just going to open the case for you. If you don't have all the stuff, we'll do some investigation. It's going to take a little longer, but we're still going to open the case for you. And then if you just don't know, you can email us. It's literally our job to answer questions. And so you can email us at taxteam@lasoregon.org. And if you have tax questions, just put tax question in brackets in the subject line, and it'll be easier for us to sort through and find those things. But that brings me to the end of my presentation, and I know that I am doing the presentation. There's also Catherine Williams at the Oregon Law Center, and we don't compete for cases. She has, the cases she likes to take, and we have the cases that we excel at. We have more staff. So that's why I say refer to us, because we have more capacity, and then we know the types of cases Catherine wants. And then we confer and refer with Catherine. So we have a very collaborative approach to the casework. We are not in competition for numbers at all. There are far too many taxpayers for either clinic to represent. So we do work really closely with Catherine to make sure that we're coordinating and we're not too lopsided. If one's overwhelmed with intakes and the other one isn't getting any, then we're definitely happy to like filter things to her and vice versa. If she's getting more than she can take and we have capacity, then we are happy to have those referrals from her as well. So I just want to make sure that people know this is not a competition, it is a collaboration. Okay. Is there anything else before we depart? Did I get all of the chat?
There was a question about sharing the slide deck, but Eric answered that you will be sharing it. So I just want to take a minute to thank you so much. One problem with presentations like this is I think, oh, I can remember that case I did wrong or that case back in the day. But that's good because now we won't make that mistake again in the future. So I just really want to thank Shannon and Eric, not only for this presentation, but for the great that work that you're doing and the resource you are for our clients. And like I said at the beginning, I've never sent a client your way and heard back, oh, they weren't able to help or I didn't get my question answered. So I really am thankful that we have this resource. I hope everyone will utilize it and ask them questions. And I will get this recording up and out, and Shannon will share the resource. Shannon and Eric will share the resources with us. And again, just thank you so much for your time and for being here. And thanks everyone else for being here. I'm going to stop the recording in case folks have more questions too.